All right, guys, buckle in because this one's a ride. Today, we're heading into a rental nightmare turned courtroom showdown. We got a tenant who signed a lease, doesn't want to stay in the property, but also doesn't want to move out. And to top it off, she's already moved out. Yeah, this one's got confusion, legal jargon, and a touch of chaos. Our judge is calm and patient. Even while the tenant, Ms. Johnson, claims she's in a hospital during the hearing, trying to sort out what's next. But what begins as a simple update quickly spirals into a full-blown dispute about what was agreed to and whether she ever truly understood it.
And that's it. So, folks, that's the call. Please move along to your calendars. I asked if you have multiple cases, attorneys, that you try to handle them as many as possible before you come to me, and then we'll address them in turn. I'll look at those defaults shortly. Thank you.
Your Honor, as far as Kiana Johnson, with this case with Pharrell, I'm in the hospital, so I'm trying my best from the hospital. I just got it. I did submit a letter saying I was in the hospital. I don't have my ADA accommodation, so I'm not familiar with how this goes. Can you please tell me what's next?
Yeah, so all we would do, ma'am, and I really do pray for your swift recovery, whatever that may be, but ultimately it's virtual, so you would be able to still talk with that attorney in a private breakout room virtually.
Okay, I just need to know. Okay, so you all will do that. I don't know how to.
They will put you in a breakout room. You'll see an icon, and folks, this is for everyone. You ultimately will see an icon that says join breakout room. Do not leave the actual hearing, this Zoom hearing, unless I tell you to, okay? I'm the only one who can dismiss you. But ultimately, you'll be placed in a breakout room, and you may have to wait because one of the attorneys may have multiple cases, and then they will address your case in turn. Ms. Johnson, they may try to get to you sooner because you're in the hospital, but we will see. And then ultimately, you'll have an opportunity to determine if you want to settle the case or if you want to have a trial, okay? And if you have a trial, we'll have to have that situated. So just be on the lookout, folks, for that icon to join, and then you folks are free to do so.
Sorry, that was my doctor. Sorry.
No problem. Thank you for being patient. If you can raise your right hand, we'll get you out of here. You swear affirm to tell the truth under penalty and perjury of the law?
I swear.
Counsel, give me 1 second. What are those terms?
Judge, this one's a little different, just to be kind of very open and frank with the court. So it's going to be an agreement. Both parties are going to dismiss with prejudice their claims and their counterclaims. Miss Johnson's lease ends on September 30th. She has agreed that if her stuff is not removed by September 30th, those items will be deemed abandoned.
Okay.
And if Mr. Thomas, who is the plaintiff, he and his wife own the property together, that if they find anything like that she leaves behind that may be considered valuable, that they will notify me and I will reach out to her and arrange for her to be delivered that.
Okay.
And then with respect to the security deposit, that the parties are going to sign a mutual release, and that when that is presented, they will sign it, and then after it's been signed, which I will prepare and give it to Miss Johnson by hopefully tomorrow, that the security deposit of $1,000 will be paid towards her, available for either pickup at our office, or I will be happy to FedEx it to wherever she wants me to FedEx it to. Does that make sense, Your Honor?
A little bit, but let me see.
Sure.
All right, Ms. Johnson, just to confirm, I just want to confirm the terms. The parties are both dismissing their cases, claims against one another, but ultimately you've agreed that you will move out your remaining possessions on or before 9/30/2025, and anything remaining will be deemed abandoned. However, if there is anything that deems valuable, the parties will hold and contact you so that you may retain it or kit it. Moreover, the security deposit will be addressed upon your move out, which you guys will do a move out walkthrough as well. Counsel, is there anything else? No money judgment?
A negative. The security deposit's not quite right, Your Honor. So it's basically she's going to waive a right to, or we're going to waive our right to the security deposit. We're just going to give her $1,000, and she's going to sign a release, and my client will also sign a release.
Okay, so forgive me, Ms. Johnson. So in lieu of that, you will get $1,000 portion of the security deposit, or just $1,000 just in general
Yes,
from the
as a
plaintiff.
judgment. Yeah.
Yeah, and then that will resolve the security deposit issue as well. Anything else that I missed? I'm sorry, you guys got quite a bit.
Is that
Question.
correct, Mr. Farrell? It's not the security deposits, it's just $1,000 judgment, correct?
Right.
Well, it's not a
Yeah.
judgment,
No.
but
No. I didn't say anything about a judgment. We agreed on $1,000 of the security deposit. I don't want any judgment against me or my business or our company. A judgment? Am I clear? A
So
judgment?
what is the clarity, Mr. Farrell?
Yeah, can you clarify?
sure. I guess it really is coming from the security deposit, but maybe I shouldn't use that word. There'll be a waiver of the security deposit. My client will pay her $1,000 upon the party signing a mutual release.
So here's the setup. Ms. Johnson says she's in the hospital, and honestly, that's tough. But this judge, he's not here for sympathy pleas. He's here to keep the legal process on track. Notice how he still reminds everyone, don't leave a hearing unless I dismiss you. That's not just formality, it's control. Virtual courtrooms can get messy fast, and this judge knows it. But Ms. Johnson is already struggling to follow basic steps. She's confused, asking what's next, and we're only 2 minutes in. It's a preview of what's coming, a long day of circular explanations and legal wordplay.
All right, so Ms. Johnson, just so we're clear, I understand, I know Ms. Attorney Farrell is clear as well, but the security deposit, they're not going to be keeping all of it regardless. Out of that, you're going to get $1,000 of the security deposit that you've already paid, and that is upon signing in a mutual release. Again, the parties are dismissing their claims against one another. You'll have to the 30th to remove your remaining possessions. Anything remaining will be deemed abandoned. However, they will keep it and potentially, if it's valuable, and contact you about it. Furthermore, upon that. Yep, that's what life likes to do to you.
Your Honor, if I may, just for clarification, she used the word judgment, and I'm no lawyer, but we didn't agree on any type of judgment. This is a mutual, amicable agreement.
I got it, Mr. Thomas.
Yeah, no judgment. We had an agreement.
I understand. But I need to wait for her to come back.
Yes, sir, I understand. Just
Ms. Johnson, can you unmute and turn on your camera? Go. Can you unmute for me?
Yeah, I'm sorry about that. I'm getting blood drawn and it just.
I get it. We're gonna make it real quick.
Okay.
You agreed that the terms are that you guys are dismissing your claims against one another, that you're going to be vacating on or before 9/30/2025, that any possessions remaining will be deemed abandoned, that anything that deems valuable they'll contact you about. And furthermore, you'll do a final walkthrough where ultimately, after you sign an agreement, they will return $1,000 of your security deposit. Are these the terms that you've agreed to?
Yes, the walkthrough of the security deposit would be returned, he said, within the next week.
Okay, well, you guys would also be required to sign a mutual release.
Yes.
Okay. Well, then I will get a proposed order from counsel, which I'll review and sign, and then I will get a copy over to you. And I pray that you do well and you get better, okay?
I appreciate it. Thank you.
All right, you guys are free to go.
Thanks, Judge. Appreciate it.
thank you.
No worries.
Thank you.
Okay, here's where things get interesting. The attorney breaks down the agreement, and it's pretty straightforward. Both parties dismiss all claims. Ms. Johnson moves out by September 30th, and anything left behind becomes abandoned property. But the key part? The $1,000 payment. It's meant to resolve everything. No judgment, no eviction, no more fighting. Basically, a clean break. The landlord pays, she leaves, and everyone walks away. Except you can already sense it. Ms. Johnson isn't completely clear on what she's agreeing to. When tenants misunderstand agreements like this, it often explodes later. And spoiler alert, this one definitely will.
Mr. Farrell and Ms. Johnson, Attorney Farrell,
Yes.
did you or Mr. Attorney Sinquit have an announcement?
Your Honor, I do. I have a pay and stay agreement on position number 4. And I still have one more tenant to talk to. And I know the court's considering position number 1.
Yeah, and so I just real quick so I can get to deal with Ms. Johnson. Ms. Johnson, raise your right hand. You swear or affirm to tell the truth under penalty and perjury of the law?
I do.
All right. So listen, I've read over your motion. I do see that the original judge had given an order for you to pay in the registry. I do understand that you had certain other conditions and that it was ultimately, that may have altered your ability to do so. And then some other things occurred. Those issues, though, don't necessarily materially address the issue of possession. They're totally fine for counterclaims, but they don't address the issue of possession. Obviously, your condition would really justify you leaving the property, right? So,
May I speak?
sure.
Okay, so as far as the position there, I did go into the property with an ADA need. I had an allergic disorder. That was addressed to the homeowner, and he said that he would make sure that there were no allergens in the home while I was there. A major allergen would be mold. That resulted from an unrepaired and unresolved and refusal to resolve without in a manner appropriately and timely. And that
Objection.
I would before.
So,
Your Honor, this,
going
we dismissed the claims and the counterclaims. I think we're in front of the court on a motion to enforce what she contended is an oral agreement. It has nothing to do with everything that happened before.
Your Honor, I'm not.
Well, hold on. I see an
Okay.
order. I see an order for continuance. I see a motion to compel rent, an order regarding such. I don't see a consent order, but I do see the motion to compel rent into the registry, which is the basis, I believe, why the writ was requested, because the $1,300 was not paid in the registry. Is that correct?
Your
No,
Honor,
Your
this
Honor.
You said
Yeah,
no.
No, Judge, you signed an order that should be part of the record, which I can, share with the screen.
Hold on. If it's then, I'm sorry. I saw them. It seems like there's been two judges. I see Block's been on here as well. So hold on.
Mm-hmm.
I see this oral agreement, but counsel, you're saying there's a different agreement? I mean, this alleged oral agreement where she's.
Judge, you signed an order. It should be in the docket. I can share the
Your Honor,
screen.
if I could, I think I had the position first. He objected. Can I go back to my position?
Just hold on. I want to see what I'm looking at first. Okay, so there's a consent agreement. That's important. And so the consent agreement indicates parties have agreed that defendant Keena Johnson and all others will vacate the property located at 2179 Diller Crossing, Tucker, Georgia, on or before September 30th at 5 p.m. and that anything left behind shall be deemed abandoned and may be removed without further order of court. Plaintiff sees anything valuable. Yeah, I feel like I remember this case. Further ordered and the judge, plaintiff's complaint, defendant's counterclaim. Yeah, so I understand what's going on. Today's the 30th, Ms. Johnson. You found a consent agreement. I'm not trying to be difficult with you, but there's generally no appeals, of the consent and modification of such.
Your Honor, I'm respectfully asking under my conditions for a chance to speak.
Sure.
And I'm gonna speak by narrative, if you don't mind.
Well, I would ask that you just be respectful of the time and
Yes,
address specifically. So hold on. Let me ask this. Why do you believe that the consent order which you signed, saying that you would vacate by the 30th and dismiss all your counterclaims, why should that essentially be not considered in lieu of your signature on such, or in lieu of the agreement that I find that you've entered into?
Your Honor, the reason being, and before I go into that, I will say that I did ask for ADA accommodations. I am a disabled party. I asked for ADA accommodations. That was requested on August 26th. Before that, in different motions.
And here comes the first big confusion bomb. Ms. Johnson hears the word judgment and immediately panics. She doesn't want a judgment against her or her business. But the attorney never said that. He said agreement. This might sound minor, but legally it's huge. A judgment implies fault or debt. An agreement means both sides are voluntarily settling. The judge has to carefully step in to calm her down, and that's where you see the challenge. He's not just a judge here. He's practically a translator.
I do not have those accommodations. Those are for hearings that are virtual.
Objection.
Well. And so
Under one basis, Attorney Farrell, just so I can keep a record of what's going on. Objection for what?
Well, that's not the motion from the court, Your Honor. I'm objecting. The motion from the court is the motion to enforce the settlement agreement.
Your Honor, in order for me to have due process in this court, I do require ADA accommodations for cognitive disability.
Well, ma'am, are you trying to say then that you didn't have the authority to enter into the agreement that you said you had the authority to enter the agreement back on September 2nd?
No, okay, I needed, because I have a cognitive disability under stressful situations, this is why those accommodations were needed and the breaks.
Well, how do we address that accommodation? I'm not trying to be rude, but
There were a list. There were about 7 accommodations. When I'm in another county, I get an ADA coordinator that I work with. I have been asking for a DeKalb County coordinator. I've not been given that. I've been told that we had to wait on the judge to at least address the ADA accommodations. They were asked for reasonable accommodations. Those were not addressed. Those were not addressed at the last hearing. That is not what I'm saying. I'm saying for me to continue forward in the manner in which we are, I'm going to put down that I'm not receiving those accommodations. I need to put that down on record. Part of those accommodations would be a support person for this hearing. Part of those accommodations would be breaks. I just got out of the ICU. My condition has been exacerbated. I've been in the ICU all week. That's another reason for the emergency continuance.
during continuance for what though? But why?
But that's why the ADA accommodations come in.
But we don't really need a hearing. And I'm not trying to be difficult, but you have to take this in consideration of how I'm viewing it. Before these things, or after these things were requested, you voluntarily entered into a consent agreement, right?
Your Honor,
don't cut me off. That's how you get nowhere. Why would you cut me off? That's foolish. So you've entered into this agreement on the 2nd of September, just less than 28 days ago, right? And
not this agreement.
Well, the agreement says September 2nd, and that you'd vacate by the 30th of September. I understand. Stop talking. I understand your physical conditions have changed because of your health, but that does not necessarily disregard the fact that you've entered into a consent agreement indicating when you would vacate. Your ADA accommodations are not relevant because really there'd be no need for a hearing based upon the agreement that you've already entered into. So I'm trying to figure out why we need to accommodate in those regards when you've already entered into this agreement indicating that you would vacate. You've created the time to prepare to leave. That was what your plan was.
Your Honor, may I?
Yeah, you can now, yes.
Okay, so Your Honor, I've had these disabilities for years. It's not just because of this. They've just been exacerbated by this. The other reason is that when I had the hearing last time, had the hearing from a hospital bed. I had just had a stroke. I had just had, that morning of the hearing, I had just had an MRI and Xanax. I had just had a procedure. I got to the hearing late. When I got to the hearing, I was right at the point where you all were going to give a default judgment, but then I said hello, and then I proceeded from my hospital bed and my hospital gown. I didn't want to be under those same similar circumstances, under medication, and having this. What I'm saying now is that the reason that I bring this matter back to enforce is, one, because what you signed was not what we agreed to verbally, and not what was said in court.
All right. Hearing 1 ends. And if you thought that was a resolution, you'd be wrong. Because round 2 is about to start. This is where things really heat up. The same case, same people. But now, Ms. Johnson wants to reopen what they just agreed to. She's claiming the deal wasn't valid, that she didn't fully understand it, and that her medical and disability accommodations weren't handled properly. It's a bold move, especially since the judge has a signed consent agreement right in front of him. The question now isn't what's fair. It's, can you undo a deal you already signed?
The agreement that he originally sent to me to sign was about 5 pages long. There is history with this counsel, and he did not disclose that. I did try to disclose that with you before, which may be a conflict. The history being is that we're on a similar case in another county. And that similar case it has the same similarities, health-wise, landlord-tenant-wise, but that case is confidential. The reason being here is that I just found out today that he subpoenaed my medical records. He subpoenaed my medical records, and I just found that out today. I was just giving that. Let me
stop. And I understand your situation, but I'm again looking at my notes from that hearing on the 2nd, and it says consent vacate by 9/30/2025.
And that's about all it says. But the agreement that you signed, that he had you sign on September 10th, we have been going back and forth after the hearing. Since then, he tried to get me to sign something that was totally different language than what you said in court.
But
And now
I'm only referring to what I have in court.
yes,
I
but what he
understand
drafted for you to sign is not what we went over in court. That is not the agreement we made. It does not only say September 30th, get out. It does not only say that.
It says the property that you'll have and anything deemed, and they'll essentially keep a value and try to have you talk through counsel. So listen, I respect you and understand that you have certain conditions. I'd like to remind you that you're telling me that the property is uninhabitable while also trying to demand to stay in the property.
I'm not asking Your Honor, I'm not asking to stay in the property. I've already addressed in my motions that I have signed a lease somewhere else. I have been out of the property
what is the
for the last 3 months. The issue is that I cannot, it's uninhabitable. I cannot go in and get my property, which includes my dad's ashes, my son's autism medications, all those things.
Who can go in?
The property I have tried to.
Are you there right now?
When I tried to go in.
Are you there right now?
I don't live there right now, but my all our belongings are there.
Are you in the property right now?
What do you mean?
Are you physically in the property right now?
I am in the temporary housing property where I signed a temporary lease. I'm on my 3rd month of rent because that house is uninhabitable.
And that's fine, but that has nothing to do with ultimately you getting the remaining of your possessions out between the 2nd and today.
The agreement.
So listen, respectfully, what I do know is that you've agreed to vacate. There's nothing in here indicating that you are required to pay rent or anything like that in the consent agreement. So Attorney Farrell, I'm not sure about the writ that's been requested because I believe the writ indicates that she's missed a payment. Now, I believe that may be associated with a prior order from the prior judge about being paid in rent, but it appears that the most recent order and the most that would be effective is the consent agreement that was done on the 2nd, indicating that she'd vacate by the 30th of 2025. That's it. So whatever your writ wouldn't be signed as is currently identified because that's based on a prior order that has essentially been overtaken by the consent. So at this juncture, I would need a new writ. Ms. Johnson, what I would tell to you is that they have to submit a new writ. I do have a consent agreement where I have you under oath confirming to those terms. The end of information here.
Your Honor, I was never under oath.
Now, this is where the emotional side of the case kicks in. Ms. Johnson brings up her ADA accommodations, saying she has a cognitive disability and that the court didn't address her requests. The judge tries to stay patient, but you can tell he's struggling to see the connection. Her argument seems to be that her disability prevented her from fully understanding the agreement she signed. Legally, that's tricky. Unless she was declared legally incompetent, her signature stands. And from the judge's tone, you can sense he's running out of patience. Still, there's a deeper question here. Should the system do more to protect people with medical or cognitive challenges in fast-moving virtual hearings? What do you think?
And it says further order in the judge parties will sign a mutual release and will not cover damage of any of those property defendant. So you guys never signed that release. I see that was I guess that's the oral agreement that you guys have been referring to.
I'm trying to continue
to be paid $1,000 from her security deposit for fitting the remainder.
They added language to that consent agreement that was not part of the agreement is what I'm trying to get to.
Okay, and which part?
It's the part where they say that the $1,000 security deposit, they have, when they presented me with an agreement to sign, the release to sign there was no contingency basis, first of all, for me to sign that release in order to get that $1,000, but they put that down there. They also were supposed to, if I didn't get all my things out, given the consideration of the situation, they were also supposed to, they agreed that I would give them a forwarding address. They would allow me to get some of the most personal, valuable things back. And so they changed that.
It says if plaintiff sees anything valuable. Well, that's not what it says in the order. It says if plaintiff sees anything valuable, plaintiff will reach out to defendant through counsel to have it picked up.
No, they agreed not to pick it up, that they would give it to an alternative address. They would send it. The other thing is that
negative, Your Honor.
So Ms. Johnson, I'll be frank. I'm
going to file a motion today. Go ahead.
You can do what you want because that's what's legal.
But that's not what the agreement. My argument, Your Honor, respectfully, is that there's more to it than that. That is not what the agreement was. When they tried to sign the release, the reason I bring up the other case is because the other case had language that he tried to include in this case. This case had simple language, and he gave me a 5-page thing to sign that excludes that, and the other.
I understand, but all I'm saying, Ms. Johnson,
You got to give me a chance to finish. Under these conditions, I do. That's why the ADA accommodations were necessary. They're not because
It
the
has nothing to
situation-
do with that. If I'll be frank with you, your ADA accommodations don't justify.
And there it is, the turning point. The judge flat out tells her, your accommodations aren't relevant because you already entered into a consent agreement. Translation? You can't retroactively claim confusion after signing a deal you agreed to on record. He's trying to make her see that this isn't about health or sympathy anymore. It's about what's legally binding. And when she interrupts him, he drops the line every judge delivers before things go south. That's foolish. You can practically feel the courtroom's collective sigh. Ms. Johnson might think she's fighting for fairness, but from a legal standpoint, she's just arguing against her own signature.